The Honorable Chief Justice and Associate Justices of the Supreme Court.
The House will come to order.
The Senate will come to order.
We're going to now have a hearing on Senate Bill 334. Senator Belliot.
Thank you, Mr. Chairman, members of the all-powerful Judiciary Committee. Today I'm going to bring three bills before you for hearing while your chairman is up in front of Business and Labor bringing three bills before my committee. And so I would ask you to treat me kindly, and we'll do the same for him up there. I have three bills this morning, 334, 332, and 333, and I want to do three separate hearings because they're different issues, but the arguments for each of the three are pretty similar, so I'm going to give most of my arguments here with the hearing on 334, and then basically on the other two bills give a much more summarized argument. In addition, some of you may recall that 4 years ago I brought 12 bills attempting to restrain the judiciary branch, put some sideboards on the judiciary branch, and I did an extensive presentation for you at that time, had all 12 bill hearings at once, and what you have before you is a written copy of that presentation that I made 4 years ago. And so I would urge you to maybe try to follow along, and I'm just going to touch on some highlights. I'm not going to go through the whole thing verbatim again. I'm going to spare you that. Also, I will say that I know, knowing the time restraints that we have now, I did not recruit any proponents on this bill whatsoever. I hope to try to make my case and let you decide based on the ideas, not based on the politics of it. So let me start. I believe we need to reform the judicial branch. The U.S. Constitution and the Montana Constitution as well have attempted to set up a limited government based upon the notion of checks and balances, that government would be divided into three branches, the legislative, executive, and judicial, and that with no branch having absolute power, we might avoid the old plague that power corrupts and absolute power corrupts absolutely. Jefferson, however, saw pretty clearly that despite the old saw about checks and balances, the fact that there is no check and balance on the court, on the judicial branch. And particularly after 1803 in Marbury versus Madison, where the courts garnered to themselves the power to overturn legislative and executive actions on the basis of constitutionality, there is no check and balance on the court. I want to say at the outset that these bills are not brought for any partisan purposes. These bills are brought because I, along with many court critics on both the right and the left, fear that the court is becoming all-powerful to the great diminishment of the power of the legislature, which is the elected representatives of the good people of Montana. Now, here's the key point I think I want to make, is that even though courts long ago grabbed the power to completely overturn the other two branches of government, in prior eras, the court imposed self-restraint upon itself to prevent abuse from all-powerful tyranny. This was done through adherence to 5 or 6 historical rules of jurisprudence, which I argue all 5 or 6 of those rules of historical jurisprudence that were self-restraint on the judiciary, all 5 of those have been abandoned by the Montana court in recent years. And I would argue even the lower courts. Courts, and let me just go through a couple of them. I have 5 of them listed there, but I'm going to go through just a couple. Courts historically restrained themselves through their own prior case law. In other words, they didn't overturn their own rulings from prior cases. But a study done by University of Montana law professor Jeff Rentz between 1991 and 1999 found that the Montana court overturned 99 of its own prior cases. And Rentz, by the way, it was the former head of the Montana ACLU, so he's by no means a right-winger. And his study found that this was astounding. It was the #1 rate in the entire country. Another study revealed that Montana courts were overturning their own cases at the #1 fastest rate in the entire nation, in fact, at a rate more than double that of the second place state. So in other words, an activist court by a very wide margin. Historical jurisprudence, also another way they restrained themselves, the courts, was that it left the power of the purse within the legislative branch. But one need look no further than the recent court rulings on school funding to realize that that restraint is no longer put on the courts by themselves. Another historical jurisprudence restraint required the court to let the law just govern itself and just to follow the case to wherever it leads at the end, and that would be the result. But the court, in my mind and in the minds of many, again on both the right and the left, has engaged in reverse engineering. Justices deciding beforehand how they want the case to come out, and then backing into some rational basis in law to disguise what is otherwise nothing more than a politically dictated decision. And I provide for you some quotes there from the chief counsel for a Democrat attorney general in this state to support that contention. And finally, historically, the citizens had at least a defense of last resort. If the court made an unconstitutional ruling so foolish as to enrage the citizenry, then the citizenry could at least amend the Constitution through the initiative process, thus overruling the court. And I provide you a lot of evidence there that even that avenue of redress for the courts is no longer feasible in the state of Montana. And I'm not going to go through all the details, but you can read that at your leisure. So my argument for these three bills is this. If the court without self-restraint starts legislating from the bench, then the people must enact some sort of restraint on the court. If they won't restrain themselves, somebody has to restrain them. Otherwise, if we don't, what you have is not just another legislative body, but a super legislature. They have all of the power and none of the constraints which Montana's citizens have placed on its true legislature, a citizen legislature which must live and work in the real world under the laws that it passes. And I need to add that this super legislature is so powerful that it can even pass laws retroactively with true Orwellian consequences. If we legislators change laws, those changes only apply prospectively into the future from that date onward. But when the Supreme Court does it, that change goes back and invalidates elections and actions of the people which were perfectly legal based on case law at the time that those elections and actions occurred. And so, again, what you have is a super legislature. So this first bill, members of the committee, Mr. Chairman, Senate Bill 334, is a bill to enact a judicial override. And again, this gets back to Jefferson's complaint that there's supposed to be checks and balances between the three branches, and yet the judiciary has no check and balance on it. If the legislature does something stupid, that action can be overridden by a governor's veto or by a court ruling saying it's not constitutional. If the governor does something stupid, that action can be overridden by a 2/3 vote of the legislature or again by a court ruling saying that it's not constitutional. So why should the judiciary be the only branch of government allowed to make dictatorial laws with no checks and balances? In fact, it could be argued that this bill, SB 334, doesn't even go far enough to create a level playing field, because all this bill does is it says that it allows the legislative branch and the executive branch together to override the judiciary with a combined veto. It in fact requires 2/3 of the legislative chamber plus the governor's concurrence to override an action of the court, and it only applies to actions of the court overruling statute. In other words, if we as a legislative body pass a statutory law, and the court then rules that it's unconstitutional or for whatever reason throws it out, that the legislature with a 2/3 vote plus the governor's concurrence can override that and say, no, that statute stands. It's our opinion that it meets the test of constitutionality. Again, since this is a constitutional amendment, it even requires voter approval before it takes effect. So what I'm asking the members of this committee to do is to allow this bill to go forward to a vote of the people, to let them decide if they want to have some sort of check and balance on the Montana judicial system. So with that, Mr. Chairman, I'm going to sit down on Senate Bill 334, listen to proponents, if any, opponents, and answer your questions. Thank you.
Thank you very much, Senator. Proponents of the bill, raise your hands. Opponents of the bill, raise your hands. Informational witnesses, raise your hands. Questions from the committee? Senator McGee.
Thank you. For the sponsor, please.
Are you sure it's me you want to address?
Yes, it
Mr.
is.
Chairman, Senator McGee.
Thank you, Mr. Chairman. And Senator Balliet, I don't have a problem with the notion at all. Let me just ask this question. Currently, if the court overextends and we wish to try to express that some way, would we not currently do that with a proposed constitutional amendment addressing whatever section of the Constitution we feel that they have overdone?
That would be the one avenue of redress
That we currently have.
That we currently have. But I would argue that it's so cumbersome as to, and so the time process is so stretched out that it's basically ineffective. Because what happens is, if they declare a statute unconstitutional, if we want to overrule that, and our only option now is to go to a constitutional amendment, it requires a 2/3 vote of the legislature, which is the same thing as required under this. But then it goes to a vote of the people at the next regularly scheduled general election, which could be a year and a half down the road. And then even then, that only changes the Constitution. So then after that election, the statutory provision that was overruled in the first place doesn't have an opportunity to be reenacted until the next regularly scheduled legislative session, and you're talking possibly 4 years down the road.
Okay.
And in the meantime, it's a moot point.
Thank you very much.
Further questions? Further questions? Just one from me, Senator Balliet. In effect, this is a constitutional, this allows the legislature in conjunction with the governor to amend the Constitution. That's basically it, right?
Pretty close, yes. Although it would be limited to with respect to a particular statute. Okay?
Right, so if they say statute X is unconstitutional, we would in effect change the Constitution so that that statute would be effective. So we amend the Constitution.
With respect to that narrow statutory provision.
Thank you. Further questions in light of my... There being none, you'd like to close?
Mr. Chairman, I think I'll just go ahead and close. And I think I'll move on to the next bill.